Okay, welcome everybody. My name's Kevin Kerrigan, and I'm the acting dean of the law school here at Northumbria University. It's my great pleasure to introduce this, the first of our Eldon lecture series for 2011-12. Those of you who've picked up a brochure from outside will see that we have a large number of really exciting and interesting lectures to come over this academic year. And I'd like to thank my colleague Deverell Capps for putting together this series this year. The first lecture will be given today by Robert Smith QC, who I'm also proud to say is a visiting professor at Northumbria University. Robert was called to the bar in 1971 by Inner Temple and took silk in 1986. He has had a particular specialism including medical legal matters and criminal law, and has dealt with numerous cases, many high profile and all very serious. Some of the cases have included or involved the following matters: scientific issues, including DNA, toxicology and blood pattern distribution, medical manslaughter, shaken baby cases, health and safety matters, environmental and pollution cases, including organophosphate poisoning. Many barristers are delighted to have a single case reported in the law reports. Robert's expertise has meant that at least 9 of his cases have been reported. And looking through the list, I won't read them all out, but I'll read some of them out. It sounds a bit like a who's who of precedent in criminal law in particular. And indeed, for some of my first-year students who are sitting here this evening, I'll be mentioning quite a number of these cases as we go through the academic year. The first one on my list is the Crown and Beedie from the Court of Appeal, which is now the leading case on double jeopardy rule in criminal proceedings. The Crown and Woolin from the House of Lords, which was about foresight of consequences as proof of intent in murder. The Crown and H in the House of Lords, unfitness to plead, and the implications of Article 6 in the context of a fair trial in an unfitness case. Crown and Bieber, Article 3 of the European Convention on Human Rights in the respect of whole life tariffs in imprisonment. Crown and Sullivan, a sentencing case on life imprisonment and the transitional provisions in Schedule 21. The last one that I'm going to mention is the Crown and Rahman and others about joint enterprise in homicide. So it's a hugely impressive list, and it reflects a wealth of expertise and a wealth of experience, which I'm really pleased that Robert is able to share with us tonight. Robert is a bencher of Inner Temple and until recently a Deputy High Court Judge and Recorder of the Crown Court. He's also served as a member of the Criminal Injuries Compensation Board, as well as being the head of Park Court Chambers in Leeds. We're delighted that Robert has agreed to come and speak to us all about gross negligence and medical manslaughter. And it's my great pleasure to introduce Robert Smith QC, Visiting Professor of Northumbria University, to you. I would just add that Robert has agreed to take questions at the end of his talk, so please do feel free to jot down thoughts that arise to you as we go through Robert's talk.
Thanks very much. Could I just ask about the composition of the audience, just for my benefit? Are there any medical practitioners here? Thank you very much. I'm pleased to see that as well, because I imagine it might be quite useful or indeed interesting for members of the medical profession as well. We often loosely refer to the Hippocratic Oath without a full understanding of its origins. The oath emerged in the 4th century before Christ, and one of its basic tenets was that it involved a recognition by the medical practitioner of the distinction between killing people and curing them. It imposed upon the medical practitioner, therefore, one of the earliest ethical standards for the profession. And it has therefore been in existence for about 2,500 years. The oath has passed in the hands of the medical profession through various modifications, with the result that it now bears little resemblance to its original form. But during this transition, it has retained one common theme which survives until today, and that is that it requires the medical practitioner to maintain the utmost respect for human life. The oath, number 2, please. The oath was traditionally attributed to this man, Hippocrates, who was born in 460 BC. But research has shown that the oath emerged at a later date, probably about 100 years or so later, and it was given this name because Hippocrates was the founder of the Hippocratic school of medicine and revolutionized the practice of medicine in ancient Greece. Number 3, please. One of the requirements of the original oath was that the medical practitioner undertook not to administer a drug which would cause death or to give such a drug to anybody who asked for it. This wasn't intended to be a prohibition on the use of ancient medicines which were capable of causing death when misused, but it was an obligation on the medical practitioner not to use such drugs for the purposes only to end life or to permit others to do so. In this respect, the duties imposed on the physician are no different, therefore, than they are today. Now, I'm sure we all recognise that modern medical science itself knows, with what is now a vast range of drugs capable of causing death if administered incorrectly or inappropriately, that a patient may be at risk of death from the use of such drugs in an effort by the physician to cure or to alleviate or, more commonly, to palliate symptoms of disease. Thus, the medical practitioner may witness the results of the drugs he or she has administered or prescribed in the form of the death of the patient, either in circumstances in which the patient would otherwise have survived, or at a point earlier in time than when the patient otherwise would have died. We know also that the use of anaesthetic agents has proved to be a not infrequent source of accidental death in patients, sometimes as a result of a failure to appreciate the effect of the drug in the patient, sometimes because the dose has been miscalculated, and sometimes because there has been a failure to take timely or adequate steps to recognise and to reverse the impact of anaesthetic agents on a sedated patient. Anaesthesia is dangerous but necessary. Now, medical history is littered with examples of misdiagnosis, lack of reasonable care, and inappropriate or incorrect treatment resulting in the unnecessary death of patients. What we need to remember, however, is that these instances, while disturbing and rendered prominent in our minds by the publicity attendant upon them, are of course a minute fraction of the cases in which the medical profession have otherwise excelled. What the law must also remember, the law, is that errors of judgment afflict all of us in our professional and daily lives. no member of any profession should be exposed to punishment for a mere error of clinical judgment, particularly one categorized as an error by retrospective analysis in the light of the consequences. Now, fortunately, since the abolition of the death penalty in 1965 and the last execution in England in 1964, the errors of lawyers no longer result in the deaths of their clients, and the consequences of their errors can be addressed by compensation. Medical mistakes can often be addressed by compensation, but the avoidable death of the physician's patient cannot. And so, the law of homicide regulates the actions of the medical profession arising from the deaths of their patients in two ways. The first is to impose criminal responsibility for the unlawful act of deliberately killing a patient, and this is done by means of a prosecution for murder. The second is to impose criminal responsibility for what's known as gross negligence manslaughter. And the former involves a deliberate and unlawful act, whereas the latter requires no more than a high degree of negligence. Now, apart from notorious killers such as Dr. Harold Shipman, and possibly and more controversially, Dr. John Bodkin Adams, who was named in the wills of 132 of his Eastbourne patients, tried for the death of one and acquitted by a jury in 44 minutes. Prosecutions of members of the medical profession for murder are normally directed to regulating the conduct of doctors in ending the lives of their patients on compassionate grounds, otherwise known as mercy killings. This has been recognised as a mitigating feature in sentences for murder by Schedule 21 to the Criminal Justice Act 2003, which specifically provides that a mercy killing amounts to a feature of the case which operates to reduce the minimum term that a doctor, or for that matter any other person, would be required to serve, and in the case of a doctor, the unlikely event of being convicted of such an offence. I say unlikely event because from time to time the Crown Prosecution Service analyses such cases and concludes that for unacceptable reasons the doctor has deliberately hastened the death of the patient, and it commences a prosecution for murder. The doctor is invariably acquitted, often without giving evidence, as I know to my personal experience, and almost always with the benefit of expert evidence in his or her support. The reason for the acquittal is that the prosecution faces very considerable difficulties in such circumstances in seeking to persuade a jury that the doctor is not entitled to take advantage of what is known as the rule of double effect. Now, the rule of double effect is a philosophical principle. It's been expressed in many different ways, and it doesn't just apply to the law of homicide. This philosophical principle applies, for example, to the defence of self-defence. The Supreme Court of the United States, in a case called United States and Vaco, pointed out that the law has long used the intent or purpose of a defendant to distinguish between two acts that have the same result. And the United States Supreme Court said this in the judgment of the Chief Justice: The common law of homicide often distinguishes between a person who knows that another person will be killed as the result of his conduct and a person who acts with the specific purpose of taking another's life. The Supreme Court cited in the judgment of the Chief Justice the common law of England in the form of the ancient writer Hale's Pleas of the Crown, and did so to illustrate this principle which Hale had used in the context of the early law, that the property of felons, people convicted of felony, was forfeit to the Crown. A person, therefore, who committed suicide, because suicide was a felony, was adjudged to be a felon and his property forfeit in consequence. So Hale used this example. Hale wrote that if a man with intent to prevent gangrene beginning in his hand does, without any advice, cut off his hand, as a result of which he dies, he is not thereby rendered a felon. For although it was a voluntary act, said Hale, it was not done in order to kill himself. The United States Supreme Court pointed out that there is a distinction, therefore, in law between actions taken because of a given end from action taken in spite of their intended but foreseen consequences. And so, this is the rule of double effect. The rule of double effect arises in the context of medical homicide when it becomes necessary for doctors to administer powerful drugs to dying patients for palliative purposes. Such was the successful defence of Dr. John Bodkin Adams, who, as I say, was acquitted by the jury at the Central Criminal Court in 1957 after a long trial, but a retirement by the jury of only 44 minutes. Opiates and drugs which are artificial opiates have the facility to cause respiratory depression and to impose, of course, that additional insult on an already dying patient. The doctor knows, when administering these drugs, that the patient's life will be shortened as a result of his or her conduct, despite careful titration of the dose. But the doctor concludes that the dose is required to maintain the patient relatively free from pain and comfortable in the face of severe disease. The result will be that the patient, though dying, will die earlier than would otherwise have been the case, and will often die from respiratory depression. Where a patient dies in these circumstances, therefore, following the rule of double effect, and indeed what the United States Supreme Court had to say in Vacco, where a patient dies in these circumstances, the death will have occurred because of the need to provide palliative treatment, and will not have been done with the specific purpose of taking life. And so, the doctor in these circumstances therefore remains compliant with the obligations of his or her profession, traceable to the Hippocratic Oath, and the law recognises that his or her intent was solely to palliate, not to kill. This is not, therefore, murder, nor is it manslaughter, either by way of a deliberate and unlawful act or by way of gross negligence. The defences are immediately obvious. The act will have been deliberate, but if its purpose was palliative, proportionate and reasonable in its administration, it will not have been unlawful. The doctor also will not have acted in breach of his duty to the patient either, since it was the doctor's duty to palliate the symptoms, and he or she cannot be categorized as negligent. However, like every other citizen, physicians need to know where they stand. Already, a moment's thought will tell us that the double effect rule is all very well, but does it tell the physician where to draw the line, and is there certainty in the criminal law? Equally, does the physician, the surgeon, or the anaesthetist know where the boundary between ordinary negligence and gross negligence manslaughter is to be drawn? An important theme, therefore, of this lecture includes the question of the importance of the principle that the law must be certain in its ambit and in its scope in order that the persons who transgress know the boundaries or limits beyond which their conduct and their state of mind becomes criminal. We all know and should know that this is a fundamental principle of the criminal law. Laws must not be vague, and any medical practitioner, together with any other citizen, is entitled to know where the line is to be drawn. The difficulty lies in defining the boundary, as we shall see shortly. One of the concerns which the medical profession is right to entertain is in relation to the stage at which palliative care of patients becomes homicide, and the point at which negligence becomes criminal. The main theme of this lecture is that doctors need to know the boundaries at which their actions or omissions may fall to be categorized as criminal. Now, the rule of double effect provides a clear route for ethical conduct which does not bring the doctor into conflict with the law. If the dose of a potentially lethal drug has been administered or prescribed in order to palliate severe pain, and the practitioner has properly titrated the dose, has borne in mind the age and condition of the patient, and has administered or prescribed only that which was necessary to achieve that purpose, rather than seek the objective of ending life, his or her actions will not amount to homicide. And this is a simple and clear approach endorsed by the law and by the medical profession. A man named Dr. Daniel P. Sulmazi is Professor of Medicine and Ethics at the University of Chicago. He has devised a test which the doctor can apply to his own conduct without the need to invoke legal advice. It's been called the Sulmazi Principle, and it's as follows. If the patient were not to die after my actions, would I, the doctor, feel that I had failed to accomplish what I had set out to do? It's a useful test for the medic, isn't it? By which the medic can test his or her actions, intent, and potential criminal responsibility. I find it compelling. If only the law could be so simple. I cannot think of any better way of expressing a test for the double effect rule in practice. Now, the rule of double effect therefore protects the medical practitioner against the risk of being prosecuted for for murder as well as manslaughter, since although the administration of a drug which will result in the premature death of the patient will have been a deliberate act, it will not have been an unlawful act. And since the lawfulness of the doctor's actions is established by the purpose for which the drug has been administered in the first place, there is no room, as many of us here know, in the criminal process, other than in strict liability cases, for the concept of prosecution based on the consequences of a man's actions where his or her state of mind is not culpable. Now, the second way in which the law of homicide regulates the actions of doctors for the deaths of their patients is the main theme of this lecture. It does so in the context of negligence, and in so doing, the law recognises that medical practitioners are not to face criminal proceedings for mere negligence, regardless of how serious the consequences of the negligent acts or omissions may be. The law of gross negligence manslaughter, in the form in which it is defined today, has its origins in the decision in the Queen against Bateman, where the Lord Chief Justice Hewitt, defined the offence as follows. And I'm going to come to this part, which is on the screen in just a moment. But first of all, the Chief Justice said this: in expounding the law to juries on the trial of indictments for manslaughter by negligence, judges have often referred to the distinction between civil and criminal liability for death by negligence. The law of criminal liability for negligence is conveniently explained in that way. If A has caused the death of B by alleged negligence, then, in order to establish civil liability, the plaintiff must prove, in addition to pecuniary loss caused by the death, that A owed a duty to B to take care, that that duty was not discharged, and that the default caused the death of B. To convict A of manslaughter, the prosecution must prove the three things above mentioned and must satisfy the jury, in addition, that A's negligence amounted to a crime. In the civil action, if it's proved that A fell short of the standard of reasonable care required by law, it matters not how far he fell short of that standard. The extent of his liability depends not on the degree of negligence, but on the amount of damage done. In a criminal court, on the contrary, the amount and degree of negligence are the determining question. There must be mens rea, said the Chief Justice. And what he was illustrating by this principle is that in the civil law, there are not degrees of negligence. That is an established principle of the civil law of negligence. In the criminal law, there must be degrees of negligence in order to permit a jury to decide whether somebody has been criminally negligent or not. Later on, the Chief Justice went on to say, explaining to juries the test which they should apply to determine whether the negligence in the particular case amounted or did not amount to a crime, judges have used many epithets, such as culpable, criminal, gross, wicked, clear, complete. But whatever epithet be used, and this is the quotation which you have on the screen in front of you now, but whatever epithet be used, and whether an epithet be used or not, in order to establish criminal liability, the facts must be such that, in the opinion of the jury, the negligence of the accused went beyond a mere matter of compensation between subjects and showed such disregard for the life and safety of others as to amount to a crime against the state and conduct deserving punishment. Now, Bateman is the fountainhead for the development of the law in relation to gross negligence manslaughter. It followed a series of common law cases at first instance in which judges struggled to define the law correctly for juries. We therefore see that the route taken by the Lord Chief Justice involved directing the jury that the ingredients of the tort of negligence had to be established by the prosecution, and that the degree of negligence involved was required to be so serious that it was to be designated as a crime. Now, from this point onwards, the criminal courts have been obliged to attempt to tackle a particular problem. And that problem is this: how is a jury to be directed to assess the seriousness of the breach of duty? Manslaughter committed by the medical profession has emphasised the problem in its most acute form. In their search for a definition which was capable of demonstrating to a jury that they could not convict on the basis of simple negligence, the Lord Chief Justice mentioned this variety of epithets. But he endorsed a test for the jury which very few jurors would be capable of applying. Culpable or complete adds nothing to the concept of negligence. Criminal invites the jury to apply a test which they're not qualified to employ. Further, it's arguable that this resulted in offending the well-established principle that the ambit and limit of offences should be clearly defined. Of these epithets, none of them are helpful to a jury other than perhaps the word gross. The problem was that the superior courts were not unsympathetic to defendants, including medical practitioners, who found themselves exposed to allegations of criminal negligence. The superior courts wanted juries to understand that the degree of negligence sufficient to found a conviction for gross negligence manslaughter needed to be very high indeed. Doctors in particular were not to be convicted unless their acts and their omissions resulting in death could be truly categorized as criminal. The result, however, was that the approach in Bateman and in many first instance decisions which had preceded it created two problems. First of all, it required the jury to decide whether the facts as found by them constituted a crime. And therefore a jury was on its face now required to decide not only an issue of fact, the conventional and traditional role of the jury, but an issue of law which they were not equipped to do. Secondly, by leaving to 12 non-medically and non-legally qualified persons the decision as to whether the breach of duty was to be categorized as criminal, offended against the principle that the point at which a doctor's acts or omissions cross the border between the civil concept of negligence and the criminal concept of gross negligence should be clear in its ambit and definition, and should as a result be capable of being understood by a medical practitioner or any other person likely to be affected by a prosecution arising out of their causative breach of duty. Now, it's perhaps just worth spending a moment reminding ourselves, which most people, if not everybody here in the audience, knows already, but let's just remind ourselves. There were then, and there remain, 4 elements of the offence of gross negligence manslaughter that have to be proved in order to establish criminal responsibility for manslaughter by way of gross negligence. And these are: first, that the defendant must be proved to have owed a duty of care to the deceased. In the case of medical practitioners, that's capable of being proved once the direct relationship of doctor and patient is created, or, as sometimes occurs, indirectly, when the medical practitioner has assumed a duty to care for a patient. For example, a consultant under whose care a patient is admitted into hospital and who becomes aware that the patient has been admitted under his or her care. The terms of the consultant's engagement and his or her knowledge impose the duty. In practice, this is unlikely to be a contentious issue in medical cases, but medical practitioners cannot be saddled with a duty of care to a patient merely because they're on call or on duty. There must be some additional element that serves to create the relationship and to impose the duty. This, however, remains a question of fact for the jury once the judge has decided that there is evidence capable of establishing a duty of care. Second, the second element of the offence is that whether by way of acts or omissions, the medical practitioner is proved to have been in breach of that duty and in consequence has exposed the patient to the risk of death. The duty imposed is a duty to take reasonable care and is to be judged by the standards of the medical profession and by the ordinary principles of the law of negligence, so that a medical practitioner will not be in breach of duty arising from a mere error of clinical judgment, nor where his or her acts or omissions were such that a reasonable body of medical opinion, placed in the situation and circumstances in which the practitioner was so placed, might have acted or omitted to act in the same way. The third element is that the breach of duty must have caused or have made a significant contribution to the death of the patient, who would not otherwise have died at the time when death occurred. The contribution must be more than de minimis, and the patient's life must have been shortened more than minimally. This is entirely in accordance with the ordinary standards by which causation in law is determined, a concept with which you will be familiar. Fourth, the breach of duty must have been so serious that, having regard to the risk of death involved, it can properly be categorized as gross. It's in this last respect that difficulties in formulation of the test have arisen and still in certain respects remain. Now, following Bateman, the case of Andrews and the DPP came before the House of Lords in 1937. It followed a long line of first instance decisions and the guidance in Bateman, a case in which a lack of clarity was apparent in the law. It's clear from Andrews that Lord Atkin entertained some reservations about the Chief Justice's formulation of the test in Bateman. For he said that, while this was not a precise definition of the crime, the substance of the judgment is most valuable, and in my opinion is correct. In practice, it has generally been adopted by judges in charging juries in all cases of manslaughter by negligence. Now, the law then took another uncertain course. For Lord Atkin went on to deal with the problem, the one we've been looking at already, the problem of defining for the jury the very high degree of negligence required before a jury could convict. Probably of all the epithets that can be applied, reckless most nearly covers the case. But Lord Atkin went on to say, but it is probably not all-embracing, for reckless suggests an indifference to risk, whereas the accused may have appreciated the risk and intended to avoid it and yet shown such a high degree of negligence in the means adopted to avoid it as would justify a conviction. Now, the law was becoming, you may think, reasonably complicated in this regard by now. And an additional complication was soon to overlay this. The problem with this definition was that the meaning of recklessness in the criminal law was at that stage itself ill-defined. And as a result of the decisions of the House of Lords, in two cases, in 1982, Metropolitan Police Commissioner in Caldwell and the Queen against Lawrence, the meaning of recklessness in English criminal law was extended beyond a narrower subjective test, whereby the defendant was to be proved to have foreseen the risk, but nevertheless decided to run it, to one which now included an additional concept of what has been described as objective recklessness, by reason of a failure to consider an obvious risk of which the defendant was not aware because he'd given no thought to its existence. This definition survived until very recently, until the case of G, decided in 2004, and a judgment by Lord Bingham. And G was a case when the emphasis was once more placed upon the state of mind of the defendant, the actual state of mind of the defendant, and the degree of risk actually foreseen by the defendant, or of which he is aware, coupled with the decision nevertheless to run it. So there then came about this shift. Subjective recklessness, a move to objective recklessness, and a movement back to subjective recklessness, because the law recognised that it was really an absurdity to impose liability on a man whose state of mind didn't even recognise the risk. In the result, the law relating to gross negligence manslaughter then followed a route in which recklessness was adopted, in many cases coming before the courts, after Caldwell and Lawrence, and before G, and indeed before earlier cases than G. And this approach had the support of the Court of Appeal in a case called Seymour, in which the court suggested that there was no longer any requirement to direct juries along the Chief Justice Hewitt's familiar lines concerning the need to look further than mere compensation between subjects and the ordinary law of negligence. The result was that some medical practitioners were being convicted after juries were required to consider objective recklessness, a particularly problematical approach for reasons I've explained, because it embraced this concept of indifference to a risk of which the medical practitioner was not aware. This highly unsatisfactory state of affairs was resolved by the House of Lords in the leading case on gross negligence manslaughter, Adomarco, but only to the extent that objective recklessness was to be abandoned now as the test and the gross negligence test approved. The result was that juries were still to be directed in terms of Bateman and Andrews, and the problem therefore still survived that juries had been provided, plainly, with an unusual test to determine the element of gross negligence, namely, whether the defendant's conduct should be categorised as criminal. Lord Mackay restated the Bateman test as follows. First of all, the ordinary principles of the law of negligence apply to ascertain whether or not the defendant has been in breach of a duty of care towards the victim who's died. If such a breach of duty is established, the next question is whether that breach of duty caused the death of the victim. If so, the jury must go on to consider whether that breach of duty should be categorized as gross negligence and therefore as a crime. This will depend on the seriousness of the breach of duty committed by the defendant in all the circumstances in which the defendant was placed when it occurred. The essence of the matter, which is supremely a jury question, is whether, having regard to the risk of death involved, the conduct of the defendant was so bad in all the circumstances as to amount in their judgment to a criminal act or omission. It followed, looking at the emphasis on those words, to amount in their judgment to a criminal act or omission, that the House of Lords now not only endorsed the Bateman-Andrews test, but emphasised that the jury were indeed to be left to determine whether the degree of negligence was so bad in all the circumstances that it amounted to a criminal act or omission. So the question arose: how was the medical practitioner in particular to understand the ambit and the limits of responsibility in these circumstances? I would venture to suggest with difficulty. Lord Mackay was to state in Adamarco, surprisingly, in the light of the history following Bateman, so far as jury directions are concerned, the following: I believe that the supreme test that should be satisfied in such directions, and this is directions to the jury generally, is that they are comprehensible to an ordinary member of the public who's called to sit on a jury and who has no particular prior acquaintance with the law. Very sensible guidance. I'm sure we would all agree. But again, how is the ordinary member of the public to be permitted to base his or her decision as a juror on a personal conclusion in relation to the question of whether he or she considered that a crime had been committed? As I've indicated, English law had long recognised as a basic principle that any citizen, before committing himself to a course of action, should be able to know in advance what are the legal principles which flow from it. By leaving it to the jury to determine whether the facts found by them amount to a crime, leaves the process open to uncertainty, and what's been described by the United States Supreme Court in a case called Graynard and City of Rockford as the attendant dangers of arbitrary and discriminatory application. Now, this principle, since we must all consider in the context of any aspect of the law now the European Convention principles, this principle is also enshrined in the European jurisprudence. Article 6 of the ECHR requires a fair trial. Article 7 has also been held to include a requirement that criminal offences should be defined with sufficient certainty and clarity. However, the jurisprudence of the European Court recognises the limitations placed on these principles by trial by jury, and it's well established in the European jurisprudence that where jury trial is adopted by a member state, a jury is not required to give reasons for its decision. Such jurisprudence is, however, based on the conclusion that a jury is to be directed in relation to the applicable law, which in itself should be clear and unambiguous in its terms. There followed in consequence, not surprisingly, a challenge to the Bateman-Andrews test as redefined in Adamarco in Misra. a decision of the Court of Appeal in 2005, presided over by the then Deputy Lord Chief Justice, now the Lord Chief Justice, Lord Justice Judge. The judgment in Misra, for anybody interested in this subject and reading further, is a very useful decision to study. One can read into the judgment the concern, not expressly but implicit, that the court must have felt in relation to this perpetual problem of directing a jury in relation to the application of the test for determining effectively the seriousness of the breach of duty before a conviction could follow. Two main consequences flow from the judgment, apart from the rejection of any challenge on ECHR grounds. These are, firstly, that the Court of Appeal clarified another area of doubt which had existed since Bateman, and that was that in determining the seriousness of the breach of duty, the circumstances must be such that a reasonably prudent person would have foreseen a serious and obvious risk arising from the breach of duty, not merely of injury or even serious injury, but of death. But secondly, the court very neatly tackled the problem of the jury's assessment of the criminality of the defendant's conduct by concluding that the jury was not in fact required to decide whether the defendant was to be convicted on some unprincipled basis. The question for the jury, the court said, was not whether the defendant's negligence was gross and whether, additionally, it was a crime, but whether his behaviour was grossly negligent and, consequently, a crime. And there's a very subtle distinction between the two. And this was a rather neat piece of footwork by the current Lord Chief Justice, who in a stroke overcame the problems associated with directions to juries on this issue, which had taken place over the preceding hundreds of years. The court accepted that offences are to be defined with sufficient precision to enable the citizen to regulate his conduct, and he must be able, if need be with appropriate advice, to foresee to a degree that is reasonable in the circumstances the consequences which any given action may entail. And the result was the following formulation of the law. In our judgment, said Lord Justice Judge, the law is clear. The ingredients of the offence have been clearly defined, and the principles decided in the House of Lords in Adamarco. We need to remember that Adamarco was binding on the Court of Appeal. They involve, said the Lord Chief Justice, no uncertainty. The hypothetical citizen seeking to know his position would be advised that, assuming he owed a duty of care to the deceased, which he'd negligently broken, and that death resulted, he would be liable to conviction for manslaughter if, on the available evidence, the jury was satisfied that his negligence was gross. A doctor would be told that grossly negligent treatment of a patient, which exposed him or her to the risk of death and caused it, would constitute manslaughter. Now, what became clear from this judgment, therefore, was that the circumstances must be such that a reasonably prudent person, one we are all familiar with in our study of the law, the informed observer, who is deemed to be in possession of and have an understanding of the facts, artificially, that a reasonably prudent person would have foreseen that a serious risk, not of injury, but of death, was created by the causative breaches of duty. And the Court of Appeal has since made it clear that the trial judge must incorporate this concept into the summing up. The direction approved in a case called Yaqub is as follows. the circumstances must be such that a reasonably prudent person would have foreseen a serious and obvious risk, not merely of injury, even serious injury, but of death. But this does not answer the question of whether the jury should or should not be directed in relation to the criminality of the conduct. What's not clear from the judgment in Misra is whether the courts must now incorporate that proposition in directions to juries in relation to the assessment of the seriousness of the breach of duty. This formula suggests that if the medical practitioner knows that grossly negligent treatment of a patient, which exposes the patient to the risk of death and actually causes death, would constitute manslaughter, there may be no reason now to direct juries that they must be satisfied that the breach was also criminal. So the question arises, is it sufficient to direct juries that if they consider the breach was gross, it would in consequence be criminal? The question also arises, what are juries to be told about the criminality of the degree of negligence which must be proved before a conviction can follow? And I would venture to submit that this was left in the air by the difficult problem that Misra sought to tackle, which flowed from Bateman and the common law cases before it. The judgment, by implication, recognises the problem created by this line of authority since Bateman and Andrews, and it seeks to steer a course away from it without acknowledging the fundamental nature of the twofold difficulty, which is, first, emphasising the seriousness of the degree of negligence involved, and secondly, in inviting the jury to categorise the breach of duty as criminal before they can convict, a position which Bateman and Andrews created and which was latterly endorsed in Adamarco, a case binding on the Court of Appeal. Could we go back to number 7? And just one before. Thank you, that's it. And the words that were binding on the Court of Appeal is effectively the last sentence. The essence of the matter, which is supremely a jury question, is whether, having regard to the risk of death involved, the conduct of the defendant was so bad in all the circumstances as to amount in their judgment to a criminal act or omission. And it's because this case was binding on the Court of Appeal that I venture to suggest that this was a very neat piece of footwork on the part of an extremely able Lord Chief Justice, who decided that the law meant not that the jury had to decide whether the conduct was criminal, but that the jury had to decide whether the negligence was so gross that in consequence it was criminal. In reviewing the circumstances in which the appellants have been convicted, the court in Misra expressed the view that the jury had concluded that the conduct of each appellant, there were 2 appellants in the case, had in the course of performing their professional obligations to the patient been, and these were the words employed by the judgment of the court in Misra, another epithet or series of epithets, truly, exceptionally bad, and showed a high degree of indifference to an obvious and serious risk to the patient's life. Now, I imagine some people in this audience will conclude that judges who had to study the line of authority from Bateman and Andrews through Adamarco to Misra may have been occupied intellectually for quite a long time, particularly in preparing their directions to juries the night before the summing up. The route which the law has followed still lacks clarity in terms of the judgments of the superior courts. And it lacks clarity in this one area which is fundamental, and that is, how is the jury to determine how serious the breach of duty is, despite the fact that the risk of death is engaged? I say this because the risk of death is insufficient to establish in itself criminal responsibility, as the judgment in Misra by implication recognises. And we know, because we've been told this in all the cases for the last hundreds of years, that mere negligence is insufficient. Thus, some formula needs to be advanced by trial judges to get over to the jury the fact that the concept of negligence, which they may be more familiar with now than juries at the time of Bateman were, is insufficient to found criminal responsibility. And what I want to stress is that the clear principle involved here is that a jury must understand the distinction between civil and criminal negligence, and they must understand how serious the breach of duty, particularly on the part of a medical practitioner, must be before returning a verdict of guilty of gross negligence manslaughter. Now, I also suggest that this problem has never been realistically confronted by the superior courts. We all know, studying a line of authority, that the Court of Appeal or the House of Lords, and now the Supreme Court, may sometimes be reticent to engage in criticism of earlier lines of authority, fearful that the law may take another wrong turn. So the question arises of whether there was ever any need to complicate directions to juries by reference to this question, which arose in Bateman, to compensation between subjects, in other words, the civil law of negligence, and by inviting them to conclude whether or not the degree of negligence was criminal. Now, the answer, I suggest, is most certainly yes. So the position that I have now reached in reviewing this matter before you is that it's necessary to express some concern that for a very long time the law was prepared to direct juries that the jury had to find that the breach of duty was so serious that it amounted to a crime, that brought uncertainty into the law because juries weren't equipped to decide whether it was a crime or not, and therefore that approach was open to criticism. What I would suggest is that taking the approach which the Lord Chief Justice took in Misra, this problem, which had never effectively been confronted by the superior courts until 2005, has now been solved. It is, the authorities show, certainly by implication, the case that the courts have struggled with the problem, and we can all understand why, because it's a difficult exercise for anybody, even with huge experience in the law, struggle with the problem of how to convey to a jury the fact that they must not convict a medical practitioner for a failure to exercise reasonable care for the safety of the patient, even if the breach of duty exposes the patient to the risk of death, unless a very high degree of negligence is involved. I would suggest, and I have to be forgiven for this, I hope, that this is why the courts have not openly or overtly recognised the obvious deficiencies involved in such a test in the line of authority since Bateman. On the one hand, they approached the problem, professional men such as medical practitioners, in a wholly sympathetic way. And they sought, on the other hand, to try to explain to juries, please don't convict this man or this woman unless you are satisfied that this negligence is so serious that it's criminal. Now, what's been achieved by the judgment in Misra is that juries can now be directed in simple terms that the defendant cannot be convicted unless the prosecution have proved, to the required standard, that the breach of duty was such that it was not only gross, but that it fell so far below the standards to be expected of a reasonably competent medical practitioner in the circumstances in question, that in the words of the judgment it was truly exceptionally bad, so as to be categorised as criminal negligence. It's difficult to think of any clearer way, I would suggest, in which to state the need for juries to understand the seriousness of the breach of duty that must be established before they can convict. It's of interest to note that the report of the Law Commission on involuntary manslaughter in 1996 concluded that no better formulation of the test to assist juries to distinguish between civil and criminal negligence could be devised than that expressed in Bateman and the line of authority up to 1996 since then. If the Law Commission couldn't formulate a better test, it's perhaps not surprising that the courts couldn't. It has, of course, been left to judges individually to formulate the so-called epithet considered to be suitable to explain to the jury how they should assess the seriousness of the breach of duty. It's interesting to note that the trial judge in Misra used the term reprehensible. The Court of Appeal considered that this was perfectly suitable. And this means that since 1918, there have been the following epithets proposed by judges as a suitable test for determining the seriousness of the breach of duty. They are, from a case in 1859, Crook, criminal inattention. From a case in 1860, culpable negligence. From Bateman, culpable, criminal, gross, wicked, clear and complete. Andrews, reckless. Misra, truly exceptionally bad and reprehensible. This has not served so far to introduce clarity into the law. Digressing slightly now, the law has also seen a recent statutory development in relation to corporate manslaughter, and that was enacted in the Corporate Manslaughter and Corporate Homicide Act of 2007. The Act requires proof of what is described as a gross breach of a relevant duty of care owed by the organisation to the deceased, which in turn is causative of death. These are, as we can see and know, therefore, familiar words based in the common law. Section 8 of the Act, however, deals with the question of jury assessment of the seriousness of the breach of duty, and it requires determination by a jury of the question of how serious failures to comply with any health and safety legislation which relate to the alleged breach of duty, how serious they were, and how much of a risk of death is posed thereby. The jury are expressly entitled to take into account, quote, any other matters they consider relevant, unquote. It remains to be seen whether trial judges in the Court of Appeal will impose an obligation on the trial judge to spell out to the jury in such cases what matters are not capable of being relevant. Otherwise, the Act becomes a charter for uncertainty in its ambit. This is, of course, modern statutory language, which we are all becoming accustomed to. But arguably, it carries with it far less clarity than the common law has now imposed in gross negligence manslaughter. The fundamental concept which the jury needs to grasp in directions from the trial judge in gross negligence manslaughter prosecutions is the seriousness of the breach of duty. That's the key issue. The way in which the Court of Appeal has now laid down the requirement preserves the concept of criminality, but emphasises the need to stress the seriousness of the breach. Now, for the purposes of this lecture, I have devised a test by way of a direction to juries, which may or may not be considered to be attractive. Who knows whether the Court of Appeal would find it attractive? But it's as follows. In the event that you, the jury, are satisfied that it's been proved by the prosecution that the death of X was caused or significantly contributed to by the defendant's actions in, whatever it may be, or omissions in, whatever they may be, and that in so acting, or if it be the case, failing to act, a reasonably prudent person would conclude that an obvious and serious risk to the patient's life was thereby created by him or her, the defendant, it would then be necessary for you, the jury, to consider whether the defendant's acts or omissions, whatever they may be, involved such a high degree of negligence that his conduct should be categorized as criminal. Adherence to Misra. In order for you to reach that conclusion, the prosecution must have made you sure that his or her conduct, in all the circumstances, was so reprehensible and so exceptionally bad, applying the standards of the medical profession as you find them to be, that it would consequently amount to a crime. Now, it is very difficult to steer a course that avoids the Bateman-Andrews problem, but tries to incorporate for the jury the concept that the conduct is consequently a crime. And the reference in this direction that I have proposed to the standards of the medical profession is a reference to the fact that a jury, in the vast generality of medical manslaughter cases, couldn't themselves determine whether there had been a breach of duty, and if so, how serious that breach of duty was, without the assistance of expert medical evidence on both questions. And there may be an issue, of course, as to what the relevant standards of the medical profession are, and that being a matter for expert evidence. This proposed direction remains, therefore, faithful, I would venture to submit, to the guidance set out in Adamarco, case binding on the Court of Appeal, a decision of the House of Lords, in relation to the jury's function in determining the seriousness of the breach of duty, and it preserves the importance of emphasising the distinction between civil and criminal negligence, as emphasised or described in Misra. And this represents the current state of the law. Now, by this route through the authorities, if I am right, and this does represent the current state of the law, the bar in medical manslaughter is not, therefore, too high. This is recognised by the Crown Prosecution Service in the application of their charging standards. There are other considerations which the law needs to bear in mind, policy considerations. And it needs to bear these in mind in regulating the acts and omissions of medical practitioners in terms of homicide. In conclusion, I need to point this out. The negligent doctor is occasionally encountered by the law, but not usually so. Compensation culture is a burden that doctors have to bear. What must be avoided is a belief by the medical profession that they're open to prosecution for manslaughter where death results from ordinary or mere negligence. What must be avoided is a concept whereby juries feel that mere negligence, where death has resulted, is sufficient to found a conviction for gross negligence manslaughter. Although the civil law does not entertain the concept of degrees of negligence, the criminal law plainly does. And so, the experience of the court shows that juries are reluctant to convict medical practitioners in the absence of a very high degree of negligence. I would suggest that this result is, for these reasons, the reasons I've given, proportionate and reasonable, and our anxieties should be entertained concerning any alternative test that might be introduced with a statutory definition of the crime, as recent legislation such as the legislation relating to corporate manslaughter demonstrates. Now, what I've sought to do with this lecture, as I hope you will have seen, is to provide the history of the development of the law relating to gross negligence manslaughter insofar as it applies to one very important area, and that is the jury. I wonder whether a medical practitioner faced with an allegation of gross negligence manslaughter would prefer to be tried by a judge or a jury. Does anybody have any views on that? Anybody in the audience? There are two medical practitioners here, I think, at least two. Does anybody have any views? Thank you.
I believe the medical professional would rather be judged by the jury because they're far more likely to be sympathetic to his cause. Yeah. They feel more humane with him, so to speak, as the judge would just follow the black letter of the law.
I entirely agree with you, and I think you're absolutely right. And I also think that on that jury of 12 people, they will have had experience of doctors affecting either themselves or their families or people they know. And the bad experiences will be hugely outweighed by the good ones and the respect that they hold for the medical profession. And this brings me back to cases like Dr. Bodkin Adams. Dr. Bodkin Adams was tried at the Central Criminal Court for one offence of murder of one of his patients. The trial was presided over by what was then Sir Patrick Devlin, who had been asked by the Lord Chief Justice to try that particular case. It was novel and unheard of. And what the press did to Dr. Bodkin Adams before the trial, in the committal proceedings before the Magistrates' Court, which were made public, as a result of the publicity, they pilloried Dr. Bodkin Adams before the trial started. They dealt with the fact that the prosecution had trailed through the Magistrates' Court in the committal proceedings allegations that Dr. Bodkin Adams had been responsible for early termination of the lives of a number of his patients. Admittedly, he appeared as a beneficiary in the wills of 132 of his patients. And the lady who was the alleged victim in the prosecution had left him a Rolls Royce, as the judge said impressively, a 1928 model, a casket of silver, and a considerable amount of money. When Dr. Bodkin Adams discovered that this lady was about to change her will so that her son would inherit these matters, but in the event of his death, then Dr. Bodkin Adams would inherit them, she suddenly received very substantial doses of morphine and heroin, enough to kill an elephant. You may think it's surprising that in 44 minutes the jury at the Central Criminal Court acquitted this man. And that is the answer to the question, and your answer: would a judge possibly have allowed Dr. Bodkin Adams to walk free from the court? Or on that jury were there 10, 11, 12 people, all of whom had experience of the medical profession, of people dying, as this lady was, and of the fact that doctors, generally speaking, seek to palliate and, if they can, preserve life rather than take it. So Dr. Bodkin Adams has since been pilloried as well. A lot of books have been written about him, including one by a man called Patrick Cullen. And the most recent book on Dr. Bodkin Adams suggests that he may have killed up to 160 of his patients. But in those days, surprisingly, it was a rule, as Lord Devlin has pointed out in a book that he wrote afterwards, which I've referred to in the text. It was a rule that the prosecution could only lay one allegation of murder in an indictment. Where that rule came from, nobody really knows, but it was the practice in the 1950s. They could have similar fact evidence, but they couldn't lay more than one allegation for murder in the same indictment. And so when the prosecution, led by the Attorney General, Sir Reginald Manningham Buller, presented this case for the prosecution, Sir Reginald Manningham Buller obviously upset Lord Devlin, then Sir Patrick Devlin. His handling and management of the case is such that Lord Devlin chose to refer to him thereafter as Sir Reginald Bullying Manor. And that reflected the trial judge's assessment of how prosecuting counsel had conducted the case against Dr. Bodkin Adams at his trial at the Central Criminal Court. In the end, it means this, doesn't it, that you are absolutely right. It's important that we preserve jury trial for cases like this. Who wants a judge to decide this sort of emotional case in a sterile environment? I would suggest that it's far better that 12 members of the public use their experience of doctors, the law and the problems that doctors have to face with dying patients or patients they're seeking to treat. I certainly, if I was a doctor, would prefer to be tried by a jury than by a judge. There's only one more thing I'd like to say, and that is this, that I've been invited to give this first Eldon lecture this term in my role as visiting professor here. And I want to say that this is a great honour for me. It's an honour to have been invited to become a visiting professor at this university. And it's also a great honour for me to have had the privilege of presenting this lecture to what I can see has been a very receptive and kind audience. Thank you very much.